Hi, I'm Vicki Roberts with Bloomberg Law here at Littler's Executive Employer Conference in Phoenix. With me right here is Bill Simmons. He is a shareholder with Littler, and we're going to talk about the traps that employers might face when looking to hire someone. Ban the box, salary history, fair credit reporting. There's a lot of laws to keep track of. And I think maybe a good place to start is salary history bans.
Sure,
there was a ruling this week in Philadelphia that I think shows how dynamic this area is.
Yeah, the landscape's really shifting. You have on one hand a bunch of bills that have been passed, some that are still in the process of legislation. On the other hand, you have states like Michigan and Wisconsin that are passing ban the ban laws in which they're restricting local cities from passing laws like this. And then you have the court ruling implications when a law like this is challenged. So in Philadelphia, the Chamber of Commerce and others challenged the validity of the law. And the court issued, a split ruling. It held that the inquiry portion of the law, in other words, whether you can ask, was unconstitutional, meaning that, on the flip side, it should be lawful for employers to ask the question about someone's prior salary history. But the catch was that the other part of the law about reliance on that information to actually set pay, which is what a lot of employers were using the information for, was not unconstitutional. In other words, employers would still be banned from that portion of the law. And of course, the litigation is still continuing, so things can keep changing.
Right. So these laws are not meant to be a trap for employers. Salary history inquiry, ban the box, fair credit reporting, these are all aimed at at leveling the playing field, at keeping things fair from the perspective of the person applying for the job. Isn't that right?
Yeah, I think that's right. So basically, the fundamental spirit of these laws is always exactly what you're talking about. But that's also what gives rise to our presentation, which is the traps that employers who are well-meaning and want to comply with the law and understand the spirit of the laws still fall into. So for instance, they might understand that the Fair Credit Reporting Act is about, for instance, letting somebody know that you're going to run a background check on them, giving them a chance to look at what you're reviewing on their background report before you make a decision. But what they might not realize is that a lot of the lawsuits nowadays under that law are about whether sentences 2 and 6 of your form are supposedly not supposed to be in your form or not, and can give rise to statutory penalties. So it's stuff like that where an employer will think, hey, I've got this covered, I know I give somebody a form and get their consent, but they don't realize quite how technical this aspect of the law has gotten.
So what should employers do? What are your sort of top tips toward employers to keep on top of this? This is an ever-changing landscape. We've got federal laws, state laws, local laws, all coming at people, and if people are operating in a multi-jurisdictional way, they have company sites across the country. How do you keep on top of this? What do we do?
Yeah, well, we're going to be covering a lot of the specifics in our presentation, but if I had to give just one example of a good idea for a company who's faced with this labyrinth of laws, and which, by the way, also implicates not just the various laws, but also all different employer systems. The recruiting system, the HRIS system, the background check vendor system. There's a lot of moving parts. So if you could just appoint one person as a sort of liaison, internal subject matter expert type, they could then grasp with the business leaders, with the tech leaders, all of the moving parts, and also be tasked with keeping up to date on the changes in the law and monitoring the news, and then reporting back to the organization. The other thing is it's really important to empower that person. So management has to understand that this is a heavily litigious, class action, high liability environment, even if on the surface, a lot of the lawsuits don't sound like they really impacted people. So once management understands that and you have the SME, I think you're a far way of the bit there to try to conquer this challenge.
Okay. Let's talk just for a minute about what you think the trends are going forward. I know that in California we have a new kind of law that deals with affirmatively disclosing pay scales. Is that something we might see more of?
Sure, it's going to be interesting to see how, for instance, the salary history ban trend goes. It starts out with just you can't ask people questions about their prior pay at the interview stage. Then California introduced this requirement that you have to affirmatively disclose the pay scale of a position if somebody makes a reasonable request for it. So far, we haven't seen any more of those sorts of laws, but you can see in this kind of environment of overwhelming concern about pay equity, possibly seeing more of those sorts of laws that require affirmative disclosures by the employer and not just a ban.
Okay, well, thank you very much.